This lecture addresses the first part of a two-part lecture on legal considerations in adaptive management. While reviewing this lecture and considering legal logistics in adaptive environmental management, keep in mind that laws exist for a reason. Failure to understand and navigate the law could result in an injunction that stops your project completely, a significant delay to the project, timely and expensive adjustments to the proposed plan, and even paying the plaintiff's attorney's fees. We live in a litigious society. The plaintiffs know the law, and so should you. To get started, let's review several misperceptions in legal considerations of adaptive management. Adaptive management does not undermine existing conservation laws, though some may assume so because of how adaptive management has been used by some agencies. Adaptive management does not authorize risky experimental management. Adaptive management does not marginalize the public. Adaptive management does not give federal agencies or actions by government entities a blank check, though this line of thinking may stem from the point that in adaptive management the full extent of the management actions are not known and could change well after the opportunity to comment or intervene in the process. Adaptive management does require accountability. The days of trust us management are over. Laws, courts, and the public require more certainty, accountability, and input. They want more access and expect greater transparency. So how do we work through these challenges? There are several means of overcoming these misperceptions. First, increase the accountability and trust within the project design by implementing adaptive management in a transparent manner. Second, articulate the process in clear and concise language and follow the plan. Consideration of adaptive management and how projects may end up in the courts leads up to the Administrative Procedures Act, or APA, which allows private citizens to challenge agency actions in federal court when the action or order is deemed, quote, arbitrary and capricious, an abuse of discretion, or otherwise not in accordance with the law. The APA is the only mechanism that exists to bring challenges of the National Environmental Policy Act, or NEPA, to the courts. It is important to keep in mind that NEPA is a procedural act and that there are no fines associated with it. You just get to do the planning process over again, though redoing the planning process will be costly in time, salary, energy, and resources. The APA is the mechanism used to file suit. It allows anyone to sue the government for not following proper procedure. The Endangered Species Act, or ESA, is challenged under the APA as well. The APA has a statute of limitations of 6 years, and challenges can come in any time during that period. The APA does allow agencies to recover attorney fees. Depending on the scope, audience, and topic, some adaptive management plans will require both adaptive management planning and accordance to federal and state and local laws. For example, NEPA Section 102(2)(c) requires that an environmental impact statement, or EIS, be prepared for major federal actions that may significantly affect the quality of the human environment. However, some level of NEPA is required whenever an agency proposes an action. These actions may be covered by categorical exclusions to NEPA or analyzed in an environmental assessment, or EA, or an environmental impact statement, EIS. There are many similarities between the adaptive management process and a NEPA EIS development. For example, both are informed decision-making processes, are interdisciplinary approaches, include public and stakeholder involvement, consider models, research, and alternatives, lead to understanding of resource impacts and responses, and include monitoring. Additional similarities include presenting a description of the proposed action, identifying alternative development options, and addressing environmental consequences. Other aspects of the adaptive management process and EIS development overlap, though have distinct components, such as the need for clear objectives in adaptive management and requirements of regulatory mitigation in EIS development. There are several considerations to keep in mind when working on an adaptive management project that falls under NEPA. When structuring alternatives in adaptive management, assess the impacts into the future and address changes through time. Anticipate the direction you will take with adaptive management and do not ignore those future decisions. The Council on Environmental Quality, or CEQ, NEPA regulations state that a supplemental EIS must be prepared under two conditions. 1. When substantive changes to the proposed action are required. Be sure to review the reading covering State of Missouri versus U.S. Army Corps of Engineers, USACE, 2006. In this case study, the USACE did not clearly outline the adaptive management process and possible next management actions in the EIS. Therefore, they should have prepared amendments. Second, when significant new circumstances or information are discovered. This does not apply to monitoring data collected unless it is truly an unknown issue that is discovered. Also review the reading covering Sierra Nevada Forest Protection Campaign versus RAE, 2008. In this case, the U.S. Forest Service, USFS, had no information at the time their EIS was completed, so all information gathered was new and could significantly change the adaptive management decision. So how can you address NEPA requirements while using adaptive management? First, be sure to develop an interdisciplinary planning and compliance team that acts as a joint team for adaptive management planning and implementation and the NEPA process. Apply NEPA early in the process, not at the end, and commit to the adaptive management approach early in the process too. These are both relevant and important planning components, and the successfully implemented plan must include both adaptive management and NEPA considerations from the start. Develop a transparent process for how actions will be implemented and adjusted over time, and project potential impacts as management actions change in the future. Evaluate your NEPA document during the assessment phase and supplement if necessary. For example, writing a memo to the file that you did review the EIS at certain decision points in the adaptive management process will help everyone stay focused and confident that the two processes are working together. Be sure to document everything in the planning process, as the importance of clear and organized documentation cannot be stressed enough. As well, disclose any uncertainty in your NEPA document, otherwise it looks as if it were hidden to the courts. Finally, if models are used, disclose their shortcomings or assumptions in your NEPA document and how they were addressed. Models are useful tools that present our human interpretation of natural systems, but they are not solid replicates of how real systems behave. There is a famous saying that goes something like, "All models are wrong, some models are useful." So be sure to document everything. Stay tuned or tune in again for Part 2, Legal Considerations in Adaptive Management.